Good afternoon. Thank you to Representative King for that introduction. And thank you for inviting me here to talk a little bit about what my boss, Patrick Morrissey, the Attorney General of West Virginia, and other state attorneys general are doing in response to an EPA that, in our view, is showing less and less respect for the rule of law. As Representative King mentioned, I am the Solicitor General in the West Virginia Office of Attorney General, which means that I'm the guy they send to argue in front of the folks in black robes on cases of special importance to the state. So I'm usually in front of a crowd a little bit smaller than this one. We've got 5 justices on our state Supreme Court, but I figure I can apply to this speech the same principles that I apply to oral argument, which it turns out are the same principles I apply to parenting. Be firm, be direct, and pretend that I didn't hear any questions that I don't like. I am very lucky to have a job that I love, working for the Attorney General and for the people of West Virginia. State Attorneys General have a lot of different responsibilities, but a very important one, and one my boss gives the highest priority, is the duty to fight against federal overreach. You all know as state legislators that our country is one in which the people gave power to 2 independent governments, state and federal. The founders saw this as an important protection for freedom. They saw the federal and state governments as a check on one another, just as the independent branches of the federal government balance each other. James Madison, a guy you might have heard of, who knew something about how to structure a system of governance, described it as a double security for the rights of the people. So what does this mean? This means when the federal government tries to intrude on state prerogatives, it is not just the role of the states, it is their duty to push back. So that brings me to my topic today, EPA. Whatever you might think about the agency's underlying policy motivations, and I'm not going to talk about those today, as state legislators, you should be concerned about EPA's pattern of disrespect for the limits on its authority and the impact that is having on your state's powers and your constituents. Let's start with what the U.S. Supreme Court said about a power grab by EPA a little bit more than a year ago in a case called Utility Air Regulatory Group versus EPA. EPA wanted to include greenhouse gases as a covered pollutant for a certain permitting program under the Clean Air Act. But by doing so, the permitting program would extend to literally millions of sources, millions, touching every household in the country. So the Supreme Court rejected that, and it said it rejected it because it was an attempt to bring about an enormous and transformative expansion in EPA's regulatory authority without clear congressional authorization. We expect Congress to speak clearly, the Supreme Court stressed, if it wishes to assign an agency decisions of great economic and political significance. Remember those quotes. I'll return to them later. Just last month, the Supreme Court rebuffed EPA again in a case called Michigan versus EPA. The agency had imposed costly technology-based requirements on power plants under Section 112 of the Clean Air Act. Again, a provision that'll be important later. That provision permits the regulation of hazardous air pollutants from power plants only if, quote, appropriate and necessary. So what did EPA do? Well, at issue was the fact that EPA read the phrase appropriate and necessary to permit it to completely ignore the costs of regulation. By its own estimates, those costs were $9.6 billion per year, compared to benefits of $4 to $6 million per year. So that's a ratio of somewhere between $2,400 to $1 cost to $1 benefit, or $1,600 to $1 benefit. The Supreme Court rejected that too, holding that no regulation is appropriate if it does significantly more harm than good. Reasonable regulation, the court emphasized, ordinarily requires paying attention to the advantages and the disadvantages of regulation. But here's the thing that was the most troubling. EPA's reaction to the case and what that reveals about the agency's long-term strategy. The day before the Michigan decision, which was the last day of the term, EPA's administrator boasted that, quote, even if we don't win, it was 3 years ago. Most of those power plants are already in compliance and investments have been made. Then, the next day, after it lost, EPA was quick to assure its supporters, saying the majority of power plants are already in compliance or well on their way to compliance. So the agency's game plan, it seems, is to flout the law and see what it can get to stick before the courts tell it to stop. That is not the way administrative rulemaking should work. It is not the way a federal government of limited power should regulate, and it should concern every single person sitting in this room. So what's to be done? Well, there are a number of major rules coming out there now or coming down the pike that raise similar or greater concerns. Almost a month ago, EPA and the Army Corps of Engineers published a new definition for waters of the United States, expanding the scope of federal jurisdiction under the Clean Water Act. In the next few weeks, we are likely to see 2 rules governing the emission of carbon dioxide from new and from existing power plants. Those are the 111B and the 111D rule that Representative King referred to. And then later this fall, EPA is scheduled to publish its new ground-level ozone standard. Today, I'll cover just 2 of those rules, the existing power plant rule and the ground-level ozone standard. I'll give you a little bit of background on what they are, why we think they're unlawful, and what you can do about it. So first, the existing power plant rule. A year ago, last June, EPA put forward what we consider to be the most far-reaching rule in the agency's history. Under the guise of imposing standards of performance for existing coal-fired power plants under Section 111D of the Clean Air Act, EPA's proposal seeks to reorder the energy economies in every one of your states to reduce carbon dioxide emissions nationwide by an average of 30% in just 15 years. The proposal is like nothing we have ever seen before. It does not require specific technologies on an individual emitter. So think scrubbers on smokestacks, right? You actually put something on the power plant itself. Instead, EPA has proposed statewide emission targets for each state based on what the agency believes each state can achieve across its entire economy. So you may have heard of the 4 building blocks, people may have talked to you about those, that EPA used to develop its proposals. The first is to alter coal-fired power plants to increase their efficiency. Okay, that sort of makes some sense. The second is to shift demand from coal-fired power plants to natural gas. The third is to shift demand from coal-fired power plants to renewable resources, nuclear, wind, other kinds of power generation. And then the fourth building block is to mandate the use of less electricity by consumers, you and me. So that means forcing appliances and battery chargers to be more efficient and making building codes greener. Make no mistake, this is a fundamental reordering of each state's energy sector to reduce demand for coal-fired power. Only the first building block involves actual regulation of existing power plants. The other 3 building blocks involve changes in statewide energy policy to lower demand for coal-fired power. This isn't what you'd expect, I think, from an environmental regulator. Rather, I think it might be something that you would see from a central planning authority. Let me give you EPA's own words. EPA's own administrator has explained that the proposed rule seeks to regulate from plant to plug. It requires states to enact a transformation, that's her word, of the American energy economy. And here's the real kicker. If your state doesn't submit an enforceable plan that meets your carbon emissions target, the feds are going to do it for you. So what does this mean for the states? It means that one way or the other, EPA will force states to change how they use and regulate energy, an area traditionally left to the states. On one hand, if states comply and submit a plan, they will have to reorder their energy economies according to the 4 building blocks. Now, EPA is going to tell you that technically you have the flexibility to decide how you can meet your respective emissions target. But the fact of the matter is that the cuts can't be achieved any other way. And these plans will not be simple, as many of you may have already learned. They will require states to redirect a lot of manpower and scarce resources that could be used on other priorities for you and your constituents. And there will need to be new rules, new laws, and in some cases, new constitutional amendments. And all of these plans will be enforceable by both the EPA and private parties. So that's one hand. On the other hand, if a state refuses to submit a plan, EPA will forcibly reshape the way energy is generated and consumed in the state. And if that's not Orwellian enough for you, we still have no idea what exactly a federal takeover will look like. EPA has promised a model federal plan for public comment, but it's not clear whether we'll even see that before the rule is finalized, which, as Representative King noted, we expect to see in about 2 weeks. Either way, there are also serious practical consequences for states: closed power plants, lost jobs, and questions about reliability and electricity rates. So as you might suspect, there are a number of legal problems with the proposed rule, and I'll focus on 2. The first is what some have called the outside the fence problem, and the second is the Section 112 exclusion. The first problem goes to the core of what EPA is proposing to do. That is, act as a central planning authority rather than a regulator of individual emitters of air pollutants. As I've explained, EPA is claiming the authority not only to require individual coal-fired power plants to use technology to reduce emissions, again, scrubbers on smokestacks, but also to reach out into the world and make states use other kinds of power, or simply less power. So some have called it EPA's attempt to regulate, quote, outside the fence of an individual power plant. Let me use another example that was offered by a fellow attorney working on these issues. It's as if EPA is claiming that to reduce emissions from cars, it can not only require that the cars themselves be more efficient, but it can make people drive less. So think about it. Building block 1, more efficient cars. Building block 2, take the bus more. Building block 3, carpool with your neighbors. Building block 4, telecommute from home. Well, it turns out that the law supports what your common sense is probably telling you right now. The agency can't do that. Again, we're talking about the Environmental Protection Agency. Section 111D of the Clean Air Act only authorizes EPA to require states to design and adopt pollution control strategies for the actual sources of the pollutants. That's literally what it says, over and over again. It says that EPA may direct states to establish standards of performance for any existing source. It says states, in applying a standard of performance to any particular source, may take into consideration the remaining useful life of the existing source. The language couldn't be clearer. EPA can make states require the source of a pollutant, in this case, existing power plants, take steps to reduce emissions. But what it doesn't have is the roving authority to require anything that would reduce demand for what comes out of these plants. But even if there were doubts about the limits of the law, which I don't think there are, because I think it's clear, there are 2 important factors that cut against EPA. The first factor is the Supreme Court case I talked about earlier. Remember, Utility Air Regulatory Group versus EPA? Remember those quotes? We expect Congress to speak clearly if it wishes to assign an agency decisions of vast economic and political significance. Right? The court rejected as unreasonable EPA's attempt to bring about an enormous and transformative expansion in EPA's regulatory authority without clear congressional authorization. And here's one more quote for you. Quote, when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy, we typically greet its announcement with a measure of skepticism. That's this case. If EPA has the authority to mandate anything that reduces the emissions from a power plant, as it claims, then it has the power to make decisions of vast economic and political significance, and to regulate a significant portion of the economy. I can think of few things of more economic and political significance than questions of energy policy. How we power ourselves goes to the very heart of our lives. Our lights, our phones, our TVs, our computers, our washing machines, our stoves, our clocks, and our microwaves. It can hardly be said that a statute that refers repeatedly to standards of performance for the actual sources of pollutants is a clear statement from Congress to assign EPA that kind of sweeping authority over our daily lives. There's a second factor, though. This is, again, something that should interest you as legislators. The second factor that cuts against EPA is the state's constitutional rights under the 10th Amendment. You remember that one, where we retain our rights? The Supreme Court has made clear that authority over the intrastate generation and consumption of electricity is one of the most important functions traditionally associated with the police powers of the states. The need for new power facilities, economic feasibility, rates and services, the Supreme Court has said, are areas that have characteristically been governed by the states. So again, if there were a lack of clarity in the statute, which I don't think there is, it should be read to preserve these traditional state powers. As many of you know, as you draft legislation, it is a long-standing principle of statutory construction to interpret laws so as to avoid serious constitutional questions. And there's another principle that requires any ambiguities to be resolved against upsetting the balance between state and federal power. So let me sum this up. What EPA proposes to do is beyond the scope of its authority under the Clean Air Act, which clearly limits its authority to standards for power plants themselves. But if there were any doubt about the meaning of the statute, it must be read narrowly, both to avoid serious constitutional problems and to avoid giving EPA enormous and transformative powers without clear congressional authorization. So that's problem number one. Problem number two. Problem number two is the so-called Section 112 exclusion, which some of you may have read about in light of some litigation that we've been involved in. And it boils down to this. Because EPA is already regulating hazardous air pollutants from power plants. Remember, that's the Michigan versus EPA case that we talked about. It cannot also regulate those same power plants under Section 111D, the Section 112 exclusion. That's why we call it that. The limitation is found in the text of Section 111D itself, the very section of the Clean Air Act on which EPA is relying for its authority to promulgate this rule. That provision says that EPA can require states to issue standards of performance from any existing source for any air pollutant, and here I quote, which is not emitted from a source category which is regulated under Section 112. As EPA itself has long admitted, a literal reading of this text means that EPA cannot use Section 111D to reach emissions from a source already regulated under Section 112. Clear enough, right? The fact that EPA has already regulated power plants under Section 112, that's the issue in Michigan versus EPA, should prohibit it from also regulating power plants under Section 111D. So why are we here? Well, EPA has taken a different position. Though it admits that the literal reading of the text would prohibit its proposed rule, it says that the literal reading should not be followed. As legislators, and I know I've said this, but as legislators, the agency's explanation should very much interest you. Be careful with how you write your statutes. EPA claims that the text that I read to you, the literal text that is in the US Code, is a mistake. Looking back at the 1990 amendments to the Clean Air Act, EPA has discovered that Congress actually passed two amendments to the same text in 1990. One that originated in the House of Representatives and one that originated in the Senate. They failed to be reconciled. Both were included in the final bill and were signed by the President. EPA's position is that these two amendments create an ambiguity that the agency gets to resolve, conveniently enough. But there is no ambiguity when you take a closer look at the amendments, and so here's your lesson in legislative drafting. Only one is a substantive amendment, right? An amendment that was intended to change how Section 111D works. The other amendment is a conforming clerical amendment, the kind of amendment that legislatures include to update cross-references after substantive amendments to other parts of a statute have been made. I'm sure you've written many of these yourselves, right? You make a bunch of amendments somewhere else in the statute, you change some numbering, you got to go back through and clean up the statute. This one was meant simply to update a cross-reference in Section 111D in light of substantive amendments elsewhere in the Clean Air Act. There is no ambiguity here because the substantive amendment to Section 111D eliminated the cross-reference, rendering the conforming amendment moot. That's why the compilers of the US Code included the substantive amendment and left out the conforming amendment. This is something that happens all the time. Our research found dozens of examples of this exact phenomenon. So let me sum up the second problem. The plain text of Section 111D prohibits EPA from regulating existing power plants because those sources are already regulated under Section 112. And EPA's attempt to escape that plain statutory text by relying on what amounts to a typo doesn't hold water. If you followed me this far, you might be wondering whether the Michigan versus EPA case, which found that EPA had violated the law in adopting its Section 112 rule, has any impact on this argument. That's a question that might come up in litigation, so I'm not going to talk about it much today, but I will say that EPA has never suggested that there's going to be an impact and has vowed to ensure that both rules go into effect. One final point on the proposed rules legality that I'd like to address briefly is Massachusetts versus EPA. I'm sometimes asked why that Supreme Court case doesn't prove EPA has authority here. You might get asked the same question. So here's the answer. In Massachusetts versus EPA, that's a 2007 decision, the Supreme Court found that greenhouse gases fit within the Clean Air Act's definition of air pollutants. That's all it stands for. It didn't say how or under what circumstances greenhouse gases can be regulated, and it certainly didn't give EPA carte blanche to do so. The Clean Air Act is a lengthy and complicated statute with different programs for different types of pollutant sources. So even though the Supreme Court has held that greenhouse gases constitute air pollutants, that doesn't mean that EPA has the authority to regulate those emissions in this particular way from these particular sources. So that's your answer when you're asked that question. And that's why, while some have pointed to Massachusetts versus EPA, the agency itself has never suggested that the case is somehow enough to uphold the rule. So that brings me to our litigation efforts. What has happened so far, and what is likely to happen going forward? Last summer, 15 states and a number of industry actors brought suit in the U.S. Court of Appeals for the D.C. Circuit, asking them to stop the rule. And we recognized that because the rule was only in proposed form and not yet final, we had a high bar to clear. Our main argument was that the court should issue an extraordinary writ, a device that federal courts have used in the past to provide extraordinary relief when judicial review is otherwise unavailable. We made 3 arguments, which I won't go into detail here. But the biggest point that we made was that this rule is going to be unlawful no matter what they do. There's no form of this rule that can be passed that can coexist with the Section 112 rule. And at the same time, we had an EPA engaged in an unprecedented pattern of promising that it will finalize some form of the rule at issue, regardless of what comments it received. The EPA's administrator said that the rule, quote, is going to happen, and warned states against putting their heads in the sand and pretending like EPA is not going to regulate. I argued the case in April. The appeals court issued a decision against us in June, basically telling us to come back and challenge the rule when it is finalized later this summer. We were disappointed in the outcome, but we'll be back. And this is where you can be helpful. Together with Texas, we are working to grow our coalition of states to challenge the final rule. So take home to your states what you have heard today about this rule. Ask your state attorney general if he or she intends to join the multi-state lawsuit. Talk to your environmental and energy regulators, your governors, your constituents. Find out what matters to them. And ask yourself about the serious policy questions. What will be the effect in your state on jobs, electricity rates, and reliability? I encourage you to think about these issues and to spread the word about this rule. That covers the existing power plant rule. Let me turn quickly to the ground level ozone rule, which I know some of you are concerned about as well. Under the Clean Air Act, EPA writes national air quality standards, often referred to as NAAQS, to limit the level of certain air pollutants, including ground level ozone. And what's happened here is that EPA originally set NAAQS for ground level ozone in 1971, and then most recently it lowered it to 75 parts per billion in 2008. It now proposes to further lower the limit to somewhere between 65 and 70 parts per billion, and possibly even 60 parts per billion. What does this mean for the states? It means dramatic implementation costs, and it means a potential drag on economic growth. If EPA finalizes the proposed rule, many states will be forced to expend substantial resources to comply. Each state will have to develop an implementation plan within 3 years. And this is while states are still working to fully implement the previous ozone standard. EPA just issued a few months ago a final rule concerning the implementation of the 2008 standards. Talk about putting the cart before the horse. In addition, as other stakeholders have said, including groups like the National Association of Manufacturers, this is going to cost a ton of money, and it's going to slow economic growth. NAM estimates that a 60 parts per billion national standard for ozone would reduce GDP by $270 billion. So are there legal problems with EPA's proposal to lower the ozone standard from its current 75 parts per billion? Yes. Unfortunately, the costs are not a basis for attacking the rule. The Supreme Court has said that Congress, in writing this rule, prohibited EPA from considering costs. Nevertheless, there are other problems with the rule. We think there are at least three. The first is that we don't think EPA has met the public health and welfare standards. They acknowledge themselves that there are no human clinical studies showing problems below 72 parts per billion. Remember, they want to lower it to 75. Oh, it's at 75 currently. They want to lower it to 70. And they've observed that the best evidence regarding ozone's effects in healthy subjects is based on ozone exposures at 80 parts per billion and above. We also believe that these limits are too close to the background levels of ozone in nature. Nebraska, the state of Nebraska reports peak background levels of 68 parts per billion. So if you are required to lower your ground level ozone to 70 parts per billion, they're asking you to take out every possible risk factor, every possible amount of human-generated ground level ozone that's out there. And finally, we pointed out in comments to the rule that EPA's proposal fails to take into account the impact of other rules. EPA's own words again. Projections show the vast majority of U.S. counties with monitors would meet the proposed standards by 2025, just with the rules and programs now in place. So why do we have to lower the standard? And with that, let me wrap up. I hope that I've been able to offer you a little insight today into some of the challenges we face from an overreaching EPA and what state attorneys general are doing about it, because we need your help. We need you to go home to your states and talk about these issues, to encourage your state AGs, governors, regulators, and constituents to engage with these rules. Ask them to join our coalition or form their own. Tell them what you learned here today and educate yourselves further. Offer to help them understand how the existing power plant rule will force your states to dramatically and rapidly change the way it uses and generates power, will redirect scarce resources to developing an implementation plan, and will essentially commandeer your time and your sovereign prerogatives. The duty to fight against federal overreach doesn't just fall on state AGs. It can't. My boss and his colleagues across the country have certain tools at their disposal, but there are limits on what we can do. We can take EPA to court, but those efforts will always depend on our ability to persuade those folks in the black robes and on the courage of those judges to stand up for the rule of law. You have your own tools. You can propose and pass state laws, constitutional amendments. You can approve or disapprove state rules, and you can access and influence your fellow lawmakers at the federal level. EPA wants to regulate from plant to plug, but that's not its job. And it's our job, mine and yours, to let it know that. Thank you.